Well, good afternoon, everybody. It's June 29th, 2020. Unfortunately, here in South Florida, we are in an uptick. We're experiencing an uptick in coronavirus cases, both in Miami-Dade, Broward, and Palm Beach counties. Most, if not all, of the Tri-County area beaches have now been closed and will remain closed through at least July 3rd and in some cases July 4th. Restaurants have now been ordered to stop selling alcohol in certain cases in bars. And we are arguing over the use of pools and opening pools. So today's video cast is really dedicated to discussing pools, basketball courts, tennis courts, and overall recreational areas. So let's take first those and then get to the pool, which I know is most of everybody's interest today. So with respect to the basketball court, again, my suggestion is right now there is no way to social distance, and as Governor Cuomo famously said about 2 months ago, and properly play the game of basketball. So you're effectively asking people not to do so, not to play it properly, which people won't do. They're going to go ahead and what's called posting up and pushing off and, putting your hand on somebody and so forth for close contact to stop that person from shooting, dribbling, advancing the ball. So basketball should be out. Tot lots, absolutely not even a question. From the risk to such young, people with kids and so forth, to the issue of that children are sneezing, sniffling, picking their noses, wiping all over the place. Again, not an issue that you ever want to be in, where we're experiencing that and having to deal with that. So tennis courts. Tennis courts, I believe, right now are at least effectively a way in which you can do sport and be outside without a great risk, even playing doubles. And I've experienced that myself. In the most part, we keep away from one another. We're running around the court. When we shift sides, we social distance on the bench, have something to drink. You exchange balls by placing them on each other's rackets, and for the most part, you know who you're playing with, and as long as obviously you're all being honest with each other, you're in a great position to go forward and be safe. The issue really becomes, I believe, with the pool area. So let's talk about pools, and let's talk about what we can and can't do with regards to those pools and the risks. So first of all, there's an issue of insurance. And we've written about this. Most of your policies, if not all, provide that there is an exclusion from any policy due to loss from a virus or bacteria. And most endorsements provide that they will not pay for a loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. So clearly, and I've been told this by many insurance agents, COVID claims will not be covered as presently set forth by your documents. Now, interestingly enough, I had an opportunity today to speak with a really nice lady who's an attorney, serves on our board of directors. I happen not to represent them at this time, but one of the issues she brought up was that her association went ahead and has bought a rider to the policy at a cost of $1,000 a month. So keep that in mind for your budgets. So that's a $12,000 a year policy, in addition to whatever other actions you're taking above and beyond your already tight budgets to care for your pool area and social distancing and wiping and so forth. In addition to the fact that this only covers the defense of counsel. It does not cover any damages that may be awarded against the association. So you get a free attorney, which is a great benefit, obviously, for $12,000 a year. But you do not get coverage in the event that a judgment is found against the association for negligence of some type or another. And again, that is a negligence that is comparative here in Florida, but whatever that amount is, it could still be a significant amount. And the problem is that you're getting attorneys who are defense attorneys who are terrific lawyers, but their modus operandi is, let's work this up if we need to go to trial, but hopefully settle the claim. The problem is that they're not going to have the money now to settle the claim, because the insurance company is going to look at them and say, no. All we are providing is the defense of the cost of defense. We don't provide the actual defense costs or settlement proceeds. And most of those people, men and women, are not used to having to deal with insurance companies that are simply going to cover them to do the case and then have to go to the client, the association, and say, hey, listen, pony up. At this point, we've been in it 6 months, 8 months, 10 months. I don't think we're going to win this, or they've shown some really good arguments that I don't know if I can overcome, and then put you in that position. And that ultimately really is what the issue here. Where's your comfort level? Where do you see this going as a board member? Because really today I'm talking to boards, because boards are the people who are making up the associations in order to make a decision how much to spend, whether to open, if we open, how will it look, if we get insurance, what type of insurance. And obviously there's this one availability that insurance companies are always coming up, as they are their businesses, with smart ways to obviously make more money, offer a product, but they're weighing that product, right? Here it is $12,000 that you're going to be paying, yet you don't get any benefit of a payout should you lose the case or should you want to settle the case. All you're getting is the cost of defense. So under these policies, these endorsements and restrictions as they are right now, no association other than ones that are willing to take over the ability to pay not only extra, but then the risk of a judgment or a settlement that they may come out of pocket will benefit from these other policies, and instead they're spending even more money on the issue of coverage. So where do we go with this, and how do we really analyze it? Well, let's talk about this. Most of you that are at least my clients or that I've had the privilege of speaking with have told me that, look, we've removed all pool furniture, tables, chairs, everything. It's a barren land. To some degree, and I've advised this, that you don't open the bathrooms unless you can really care for those. And when I mean care for those, I don't mean every hour, every 2 hours clean them. What I mean is you have an attendant there who sees so-and-so go into the bathroom. When that person, that lady, that gentleman, that kid, that child comes out, that they immediately go in and wipe everything out and disinfect it. If you can't provide that service, your bathroom should be closed. And until such time as the health department or code comes out and tells you, listen, you can't keep operating this pool without the bathrooms, even in COVID, then you got to shut it all down. Until that time, at least you can try to maintain the pool and pool area while keeping the bathrooms closed. But of course, always a risk. I just think it's a nominal risk at this point compared to everything else that's going on. So now we get back to just the pools. So the pools, you have a lot to do here. You have to make sure that people are bringing in their own things. You have to be making sure that after the use of anybody of the pool area, gate, so forth, it's being wiped down. You have to make sure that they're social distancing. You have to make sure that in the pool, only families or friends that came with those families are attending together, and they're not mixing and matching, and it's becoming an all-out party like you see on TV with those areas that haven't social distanced and where COVID has clearly spread. You have a lot there that you are relying on. Now, who are you relying on this? Security personnel? Great. You probably have a big gentleman or a very, assuming lady, I hope, who's at that facility now espousing themselves as the authority on whether you can stay or go. Whatever sex that is, right? It doesn't matter. I'm not trying to be sexist. I'm trying to say that you need to make sure whoever is at that pool doing the work on your behalf has the commanding authority to say to somebody, leave or separate or if you don't separate, you're going to have to leave, one or the other, right? So that's the first thing. Second thing, you have to make sure that they're trained properly. And in other words, that you make sure that that person is not sitting there giving, taking a request back from an owner saying, listen, they're friends, they live down the block, we know each other, we've been social distance drinking, eating, barbecuing, whatever it may be, let us do this, in opposition to the edicts that you've already received from the association of how you're supposed to conduct yourself. So all these things, you have to ensure yourself as a board that the personnel that you have now hired and have put in charge of the pool area and the pool are adhering to that. How do you know? So some of you have security cams and you have maintenance personnel, management personnel inside your buildings looking over this. If it's a HOA, if it's a condo, hopefully you have these means available to you. If you have these means available, now you have hopefully a second tier overseeing all this. What if they're not? What if they are busy with something else for an hour or so out of the day and then come back to that? What if they miss something? What if? And those are the issues that really come to the forefront when you look at adhering to these policies and using them in a way to protect the association from litigation. So let's kind of retract now so we don't go back at the very end. Right now we have a situation where you have personnel that you've hired and you're spending good money to oversee the pool and those attending the pool. You now have a rider for another $12,000 above and beyond that that's going to allow you to have defense of the claim. However, you still are exposed because if I sue you or another lawyer sues you on behalf of a client who got exposure to COVID-19 on your property, any payout is not covered. So either the insurance defense lawyer will tell you after a while, look, I don't like where this is going, you need to consider it, and now you will have spent $12,000 on the policy, X amount of dollars on security, on cleaning, XXX, and now you're going to pay out something that you may not agree with. And you're going to look at this and say, well, what's my chances? And obviously that counsel will hopefully be able to, and I'm sure they will, give you some feel for it, but one doesn't know because not a lot of these cases have yet gone to trial, if any that I'm aware of, where juries are providing any type of awards. And by the way, as an aside, here in South Florida, at least, Palm Beach, Broward, Miami, there will be no jury trials until sometime next year anyways. So this is not something that's going to pop real quick and you're going to have a better feel for what the damages could be because it simply doesn't exist yet, the opportunity to go to a trial. Clients ask me all the time, what about a waiver? And this is really the overwhelming reason why I came today to, again, address this. I've addressed it on a number of occasions before. What about a waiver, guy? Why can't we do a waiver? Let me explain it as best as I can and as common sense as I can. You go to visit Disney World, Universal Studios, you go to see a concert at the arenas, one of the many arenas we are blessed to have here in South Florida. You're purchasing the right to enter that property. You have a ticket. The ticket's going to give you all your waivers, all your duties, all their duties to some degree. Any expressed liabilities, any expressed exclusions, so forth will be on that ticket. You don't have to go into Disney. You don't have to go into Universal. You don't have to go into the many arenas to see a sports or a concert or what have you. You choose the right to do so. So now you've entered then of your own volition, you have paid the fee to get that right to go in, and based on that fee and on their conditions of owning that venue, leasing the right to the venue that night, owning those properties in Disney, Universal, so forth, you now have agreed to their terms and conditions in using those facilities. And if they seek a waiver from you, then you have to do that, or you have to agree to that, or they can prohibit you as a qualification or a requirement to coming in here of signing one. So I don't sign the waiver, no problem, Mr. Shir, you don't have to. Please, you cannot attend the Disney World today, or Universal today, or the concert today, or a political rally, whatever it may be, you don't have the right to attend it. Because there's no constitutional right for me to go to Disney. They can't discriminate against me But if everybody who comes to Disney has to agree to a waiver, then I too have to agree to a waiver if I want the same rights to attend a function or a day with my kids or so forth at Disney World, Universal, and so forth. So how is that different from the pool? Well, I'm hoping many of you are guessing right now, you own the pool. Every one of your members, whether an HOA or a condo or a co-op, has a percentage ownership interest in that pool, in the basketball court, tennis court, so on and so forth. You don't own it outright, otherwise you could do whatever you want with the pool. You can charge your neighbors money to use your pool. You own one, whatever that is divided by the total number of units in the community, not the members, but the units. So you own, there's 100 members, you own 1/100th of that pool. So you don't own it exclusively, but it's yours to use. So if it's yours to use, what do we look at next when we're making this analysis? Well, we look at the maintenance, repair provisions, and so forth. The association's board of directors is clothed with the obligation to maintain, repair, upkeep of all of the, obviously, associations, HOA, common areas, condos, common elements, whatever it is, these common areas. Let's just call them generically for everybody a common area. So if the association already has the obligation to maintain it, then the assumption is that as an owner, I don't have to waive anything to use what's already mine and what already the association's obligated to maintain, and I should have a full right to do so without any exclusion. And that's why I believe, as do many of my practitioners in this area of the law, that if you were to require me, Guy Shir, as an owner, to sign a waiver, it wouldn't be worth the paper it's written on. Because the argument would be, sure, Guy signed it. Why did he sign it? Because everybody else was signing it and I couldn't get into the pool. But did the association have the right from the inception, from the start, to make me sign it? Well, no, because it's already my pool. And the board already has a obligation of what to do. And that's when the board comes and says, either A, we believe we can adequately secure the area, adequately protect our members, adequately clean it, and do what we need to do under the CDC guidelines, or B, we can't, and we're not willing to put you at risk, and by the way, our members at risk, and therefore we're going to keep it closed. So how do the members become at risk? Well, the members become at risk very simply. In the event of a successful suit against the association, then what ends up happening is there's a judgment against the community. Each one of your assessments guarantees that judgment. So how does that work really? Well, similar to when you pay your assessments monthly, quarterly, yearly, twice a year, there's a budget made, there's bills that have to be paid, and you are assessed accordingly. Well, now, in addition to those budgets, there's going to be another assessment, a judgment, something that a judge or jury, depending on how the plaintiff brought the case, has decided that they filed, and a decision has been made as to what, if anything, they should be reimbursed for those damages, death, injury, permanent injuries, what have you. That comes against the association now, since insurance, even with the riders, doesn't cover it, the association has to cover it. What secures these judgments? Very clearly, the assessments that you pay. So every owner pays money into an equal amount, unless it's different types of units, depending on your documents, but for the most part, every owner pays the same amount, and that amount constitutes the budget of the association and pays for any expenses. So if there's a judgment against the membership, the association, then the members have to be special assessed to pay that off. And how does that work? The association would then go ahead and say, okay, all of you, let's go ahead and click, click, click. This is what everybody owes. Let's pay it out. Let's say that's not a sufficient amount. Sufficient being, we want 20 years to pay out this multi-million-dollar judgment. Well, then the plaintiff can ask for the court and petition for a receiver. A receiver is somebody appointed by the court, usually somebody with an accounting background, who's also paid for now by the association moving forward, who comes and looks and says, okay, XYZ HOA, your budget is so-and-so, your values of your homes are so-and-so, the judgment now against you is so-and-so, there's a shortfall of this amount, I need to special assess everybody X amount of dollars over instead of 10 years, we're going to do it over 18 months, and that's what I'm going to recommend to the court. And my fees are X, and they'll be included in that special assessment. So you're going to pay me, and you're going to pay the judgment off. And by the way, any owner who cannot afford to do that, we will unfortunately have to foreclose against your residence to pay for that amount that you're now paying outright as part of the special assessment, like any special assessment. That could be devastating to a community and to a large number of its members. And is that something worth it to use a pool? Again, I don't believe so, but that's not my job. My job is to tell you what can and cannot happen with regard to these causes of action. So the next question is, well, Guy, I'll tell you what, I'm not going to use a pool. And I'll relinquish my rights until COVID is resolved one way or another to use the pool. And by the way, I also want you to reduce, as the association, not me, Guy, personally, but the association to reduce the percentage by some amount of what I pay because I'm not using the pool. So, one, we can't do any of that. Why can't we do that? When you buy into a community, you have a set of documents. Your documents tell you what your rights and obligations are. You have an assessment to pay for all of the amenities in the community. Whether you use all of them or don't use all of them, you have to pay for all of them. If you got to choose what ones you paid for and whether you used them more one month or another month, and based on that, you went ahead and increased or decreased the amount you paid, can you imagine what turmoil that would put association budgets in? So you have no right to come back to the community and say, look, I'm not using the pool, basketball court, tennis court. My kids are long gone out of our house and are in college, and we don't use the tot lot. Please reduce my amount of assessments by this month, every quarter, or every year. You don't have a right to do so. Even, in fact, in my own community, we have a tot lot area. I haven't used it in years. I still pay for whatever renovations, restorations, maintenance has to be done, replacement of that tot lot, of the basketball court, of the tennis court, and of the open areas. We don't have a community pool. So all of those areas I pay for whether I use them or not. Happens to be with COVID, I'm using tennis now a lot more than I ever did. But I rarely, if ever, use the basketball court. Yet I paid for the resurfacing, for the painting, for the hoops, for the nets, and for the constant maintenance of the same. It is an association amenity, and as an owner, you don't get to choose which ones you do pay and which ones you don't pay, and just because you're not allowed to use one doesn't mean you don't pay for it. Think about it this way: if the pool was being resurfaced, okay, the pool was being resurfaced, and it was shut down for 3, 4, 5 months, would you have a right to say to the association, hey, I'm not getting to use it because you're resurfacing it, and I want to have the right to use it. Until then, I don't want to pay. Absolutely not. That's part of maintenance, that's part of repair replacement, which you're paying for so that there's many more years to come of the use of the pool. You can look at it similarly with this issue with regards to not being allowed to use the pool. We still have to maintain it, and when I say we, I mean an association, still has to maintain it, still has to make sure it's properly chlorinated, that once this is all lifted, and God willing it will be sooner rather than later, that it'll be ready for your use and won't need extensive work thereafter. And that is why when you look at it, I'm just looking at my notes and making sure I'm covering everything, that's when you look at it, you see all these different aspects and all these things that people are yelling and screaming and saying, and I get it, right? I get it. Everybody wants to use the pool. Everybody wants to know that they have an opportunity to do so, and is tired of being cooped up and doesn't want to drive all the way to the beach, which, as you heard me say earlier, are now being closed as well, and is looking for an outlet. And I understand that. The problem is that when you jeopardize, when you put yourself in jeopardy of getting it, and there's contact testing, and I've gone through this in prior videos. I'm not going to discuss it again, but I want to assure you that a competent law firm filing a personal injury case for death or injury or lasting injuries as a result of contracting COVID when they believe it to be at the association's property is going to find a way to tie in conclusively, or as our civil courts require, more likely than not, 50% plus one, that it occurred at your property as a result of your actions or inactions as a board, and that you should be financially responsible for that. And that's ultimately the risk that each and every one of you take when you try to force the boards as owners to open it up because you want it open and because people are saying, this is BS, everybody else is doing it. First of all, not everybody else is doing it. Some associations are doing it, clearly. And the nice lady I spoke to today, her association's doing it, and they believe that they have it covered. Do they? I don't know. If they don't, it's going to cost them a lot of money. In addition to all the resources that they put into maintaining the pool area right now, in addition to the additional coverage that they have for insurance defense, the actual judgment itself, any settlement will have to be paid out by the members. No insurance will cover that. And I don't know if at that point the members will be so happy to do so, and it's also going to depend on what the injuries are. Right? If it's something substantial like, unfortunately, and God forbid, death, can you imagine the judgment against that association, that would prevail? Again, taking those steps, and I'm not going to be completely one-sided here, taking those steps that this lady told me they are, which is security, which is somebody cleaning constantly and so forth, can minimize, can substantially reduce a potential judgment. Will eliminate it? I can't tell you that, and the odds are no, it won't. So for all of those reasons, it's simply not a good opportunity at this point to take these on and open your pools and expose your members to potential, first of all, injuries, because that's who really is using these facilities at this time. Injuries, death, permanent injuries, so forth, loss of lung capacity, all the things that are associated with this, and secondary to that, a financial hit that can be considerable against any one owner being assessed who may already, because of the situation and loss of jobs and or downscaling of jobs and salaries, be in a financial turmoil. So I want to see if there are any questions, because I'm trying to keep this short and sweet here. And I really appreciate everything, going and discussing this. Here we go. Let's see if there's any questions. All right, well, I don't see any. If you haven't made a question and I simply haven't seen it or read it yet, then please come to me and let me know. Let me know that you haven't, you had a question or two that you want answered, and I'm going to be more than happy to do and to provide you that answer. Okay, I do have a couple quick questions here. Is having a property manager watch the pool by live feed on camera enough? Well, my thing is no, right? One, you're burdening that property manager. What if that manager cannot control the situation, kind of like I spoke about earlier with regards to security personnel, right? Even if you have security personnel, what if they can't control the situation? So now you're leaving it to a property manager who has other tasks and other obligations and can't just sit there looking at a screen the whole time, has to, in addition to looking at a screen, conduct their work. So I don't think that's going to be enough, and I, again, think that whatever steps you take, even with security, even with a constant cleaning, somebody cleaning, that a good litigator, a good personal injury litigator is going to look at this and say, how much is your landscape budget? How much is your miscellaneous budgets? Why didn't you put those budgets in and have 3 security personnel roaming, have 2 people cleaning, whatever it will be more than what you've already done? A jury looks at it and says, well, wait a minute, they're spending, I don't know, 20, 30, 40, 50, $100,000 on landscape. Maybe they should have only spent $20,000 on landscape and $80,000 on making sure that people can use the pool. Which, by the way, then takes the people who are not using the pool to come back and say, well, wait a minute, where's my landscaping? I never use the pool. Why are we giving the pool more financial backing now than we ever have before because of COVID, and taking these risks while making the community, not maintaining it, not keeping it up to the par that we're all accustomed to when we come here? It makes us feel good, helps in sales. you're going to have these polar opposite arguments from the same members of your community, those who use, those who don't use, going against you and how you use the money. So it's a really risky endeavor. How long can we keep a pool closed before it's too long? What if this goes in for 2 years? Listen, I think that's a really good point and a really big concern. The problem is we don't know yet. We do know that there's a lot of vaccines on the going to be marketed in the next, hopefully, 3, 4, 5 months. Maybe something available in early 2021. We know that doctors are talking about better ways to treat somebody getting it, to avoid or to greatly reduce the possibility of death or long-term illness from it. So I think the answer is not to look 2 years ahead. I think the answer is look to reassess every 2-3 months. Wait to see what happens or doesn't happen, and then at that point go ahead and discuss it. How's it? Let's see. I got another one. How possible is it to point the finger at the association that is where they contracted COVID? Great question. So again, contact tracing. Right now, if you hear on TV, they're able to go ahead and, let's say it's me, God forbid, I get COVID, and I was at the pool of my community, which doesn't exist, so it's an easy example. So they ask me, Guy, where have you been over the last 2 weeks? And I give them a list of places. Let's say it's real easy. I've been at my house, my office, and the pool. And they go to my office and they look who's been here in the office. Has anybody tested positive? Nobody. Has anybody come down with symptoms? Nobody. Everybody coming to work? Everybody. My house, same thing. Everybody's fine. Everybody's functioning. At the pool, they find out that 1 or 2 people or 1 person has contracted COVID and is tested positive and is self-quarantining right now. Boom. Contact tracing. Done. Fait accompli. We found where it happens. Could it be more difficult than that? Absolutely. If I'm a law firm with a lot of money and I think I can get a 6-figure plus judgment against an association, then I'm willing to take the risk and put in $10,000, $20,000, $30,000 to make sure that I've properly done the contact testing, which they're talking about doing anyways, and which they're implementing as much as they can. I'll spend that money because I've got a client who's in really bad shape as a result of contracting it, or God forbid, has passed on from contracting it. So putting $10,000, $20,000, $30,000 for a payout of 6, 7 figures is well worth it. Okay, with that, ouch, yeah, I couldn't agree more. And that's a risk, and that's why is using the pool that important that we do so. It's easy for me to say no. I'm blessed that we have a pool. My kids use the pool. I rarely do now, but we have a pool to cool off on. But is that worth risking a claim against the community where I would live? I would vote against that. I voted and I maintain that basketball courts shouldn't be open, tot lots shouldn't be open, tennis courts only to the degree where you are continuing to social distance should be opened. Well, great question. Can we get sued for not opening? Wow. Well, so here's the my light system goes on and off with the movement. So here's the short answer to this. Short answer is I don't know, but I don't think so. And here's why I don't think so. Paramount in any corporation, let's remember, you guys are a corporation, right? Every association is a corporation, not for profit, but a corporation. Every corporation has a board of directors. As long as that board is conducting themselves pursuant to their business judgment, and there's a lot of limitations on this, and there's a lot of caveats to this, which I can't address in a YouTube video right now. But for the most part, if you're looking at this and the board comes out, and I've helped my clients write specific language that alerts the people as to why we're doing it and what's the basis on this. And for the most part, we've gotten very positive feedback from owners understanding it after reading why not. If I'm a board member and I come back and I say to the community, look, we don't have the resources, we don't have the money, we don't have the personnel, we don't have the ability, and we can't guarantee your health, welfare, and safety while using the pool or the pool area, and we're going to keep it closed because of paramount importance to us is your safety, that of your family, friends, guests, invitees, so on and so forth. I don't think there's one judge in the Tri-County area who's going to look at that board and say, well, yeah, I get COVID. Who needs a mask? Go have fun. You know what? You only live once. I think a judge is going to come back to the owner going, are you kidding me? Are you really serious? This board appears to me to really be thoughtful, has looked at the issues, has addressed them with the membership, has expressed to the membership why, what, and how, and I'm not going to second guess that board's decision based on that well thought out plan. And that's what you really need. You need a well thought out plan that you espouse to the members, and they take that and appreciate that in a sense of, let's read it, let's understand it, and then I think you'd have that harmony. Not perfect. There's still communities. I've been told after I've given a Zoom talk at one of my communities that I represent, where a number of owners falsely came out and said, I'm wrong, and I don't know what I'm talking about, and everybody's opening up. The truth is not everybody's opening up. And as you see, those who opened up really are at the forefront of problems here with this increase in COVID reporting through the Tri-County. Do you want to be that association that lets people use it while it's spiking more and more? Release of responsibility. I did that earlier, so if you will watch the video after it's done, I did address releases and so forth and how that works and really doesn't work in the sense of an association. So with that, I'm going to bid you all a good afternoon. If you like these videos and you want more of them, and I love doing them, I really love to provide my clients with insight and information, please click on the subscribe. That way more content will go to you. You'll be notified easier. I want to get away from all these mass emails if I can, sooner rather than later, and just go and announce it through the YouTube channel. So please subscribe, click on the bell, so you're provided that information as it's made available to everybody. I want to thank all of you and really appreciate your time. I'm hoping our videos, we've upgraded our equipment, we've messed around with the video program that we use, so there's no buffering, there's no issues with voice. I want to really thank my IT department, Mr. Roy Guthrie, who's done just a terrific job with my IT and my ability to communicate this way. Thank you all. Please be safe. Don't hesitate to contact my office with any questions, and we really appreciate your patronage and doing business with the firm. All the best. Thank you.